It's disorganized. And let's assume that the bank did violate the act. Like, first and foremost, there's a statute of limitations. Many of these that's a limitation period to assert the claim. Many of them are 1 year. They're as short as 1 year. Judge Cannon, down here in South Bay, repeatedly has held, in different cases, absent a tolling of the statute of limitations, begins to run from the close of escrow. So the odds of catching a client timely is slim. Now, and let's assume that we did catch a client timely. What does that give? What right does that give us? Let's assume that the bank did violate the Truth in Lending Act. Let's assume that they did violate the Real Estate Settlement Procedures Act. Well, they can be disgorged of some fees, which is usually going to be measured in a few $1,000s, $10,000 or so dollars. But it gives the client the right to rescind the contract. But you got to be careful in the law. Be careful what you ask for, because you might get it. If you rescind the contract, what happens? The parties are restored to the position they occupied prior to the rescission or prior to the contract. Does that mean the homeowner gets a free house? No! Does he get a free loan? No! He gets to give back the money. Is that much of a solution? No. No. You have to look at what remedy is available and is it meaningful to the borrower. And they need to be made aware, preferably by a lawyer, that the contract may not be worth the paper it's written on. Do they want to take the risk? There is nothing that can be done to eliminate that risk. If the lender does not want to play ball, they don't want to play ball. As I said at the beginning, short sale agreement, you're changing the deal. If the bank refuses to give you the change that you're looking for, well then the original deal stands. Okay? Now, sequence of signatures. Preferably, we would want the bank to sign it first. As long as you get the bank's signature, that's fine. But it creates a procedural or logistical problem if you sign first and the bank signs and never provides you with a copy with their signature. It does represent a bit of a problem. Because a lot of the time, after your client signs and sends the paperwork back in, the bank just moves on. You sort of become lost in the shuffle or forgotten about. Then you start making phone calls. You say, well, I need a copy of that. And the person that you're talking to on the phone is probably working in a customer service department or something. And they don't have authority to pull files. I don't have authority to provide that to you. Well, who does? I don't know. Well, let me transfer you to another department. And you start going through this. So the best time to get the bank signature, if you can, is get it from them up front. Get it from them up front, if you can. If they don't, logistically, yeah, you're going to have a problem, possibly, trying to get them to sign it and send it back to you. But you do need the bank signature if you want to hold them to account, hold them to the deal. Next question. We're right up here.
Along the lines of signatures, not that the bank does this, but what is the validity of the digital signatures like DocuSign on real estate contracts?
Good question. She's asking about the validity of a digital signature. Ideally, what you want to put in the agreement is there should be language in the agreement that says a digital signature shall have the same full force and effect as an original, and that the agreement can be signed in counterparts. You want to have language to that effect in there.
So maybe have a separate agreement where your client physically signs something that states that they are authorizing you and giving the
well, you're going to want it, but no, how does that help you? Because if you're going to ever end up in a courtroom trying to enforce the agreement, whose signature do you want to see on there? Whose signature are you primarily concerned with? The lender's. The lender's signature. But ladies and gentlemen, I'm going to tell you right now, you're going to encounter a lot of resistance from the bank. I mean, it's not so much resistance that you're going to encounter. You're going to encounter indifference.
If they receive what
Yeah, they're just going, oh, you know, because they don't understand this. The banks view you as aiding and abetting the bad guy. They really do. That's how they look at you. That's how they look at you. Don't expect professional courtesy. Don't expect customer service. Not when they're getting stiffed. Expect an adversary. And if you're taking the side of the combatant on the other side of the battlefield to them, then they're going to likewise see you as a threat. Question in the back.
Is the negotiator that performed the initial sale approval, is their signature adequate for the component bank?
The negotiator. Well, there's a question of
Short sale.
on the short sale. Well,
Is that adequate as the bank signature?
it would be better. I mean, it's a question of authority, ostensible authority. Arguably, it should be. I can't. The bank personally. I mean, it should be somebody that has been given authority, and if they're the ones signing it. Here's how that plays out. If it turns out that they don't have authority, then whoever is signing it is going to have a problem.
How do we know they have authority?
You're going to have to ask the bank to demonstrate to you that they have authority.
Should that be enough? Like if somebody from the bank, a bank representative signing it?
The odds are, let me put it this way, what you have there, you're playing the odds. Odds are it's not going to come back to haunt you, but it's possible that the bank come back and say, well, that person is a rogue employee and they didn't have authority to sign on our behalf. They can try and argue that, and that's what you're concerned about. It's a valid concern. But it's going to be a hard sell. It's going to be a hard sell for them to make that assertion. I had a case a few years back where somebody tried to do that to me on one of my clients, and I sued the employee. I sued the employee that signed it. And then he went back to the employer and filed a lawsuit, a cross complaint against his employer under the labor code to indemnify and hold him harmless. And so we got around it that way. But it's possible, but you are assuming a little bit of litigation risk there, but I would call it a little bit. I'm not overly concerned about it. Out of an abundance of caution, you can go back to the lender and say, hey, show me that this person has authority to bind you to contracts, and then see what they say. We should see what they show you. If they say nope, we're not going to do that, then you just have to go back to the client and say you got to talk to the lawyer. I'm not sure exactly what this legally means, but the lawyer's going to tell them exactly what I'm telling you. Is yeah, you assume a little bit of risk there, but the odds are it's going to probably work out okay, but you can't guarantee it. Yeah.
What are the chances of the post-sign negotiation?
What's that now?
Post-sign, you close a deal, promissory note. What's your chances of negotiating back?
You're saying a client signs a promissory note when
For the second.
for the second.
So to facilitate the transaction.
Well, why would they sign the Why do they sign the promissory note?
Because
See, the question is, here's where that gets a little scary. The question is, did the client have a legal obligation to pay on the second? If they didn't have a legal obligation to pay on the second, then a lawyer looking at that may then turn on the realtor and say, why? Why? Why did you have him sign that? We want you to pay it now.
so if it's done, what can she do?
Well, has she been making payments?
What do you mean payment on the promissory note?
Yeah. You got to be careful with these promissory notes, ladies and gentlemen. I mean, My whole, regardless of whether you win or lose, you don't want to be a defendant in a lawsuit. This whole issue with promissory notes is it's fraud. It's a form of fraud to make a promise where at the time you made the promise you did not intend to perform.
Okay, she got her home equity loan. Now, my question is, she was told that afterwards she could probably negotiate.
Who was she told that by?
Negotiator?
Who's the negotiator? Who's the negotiator work for?
Company?
What company? Who's the? Are you talking about the bank?
No, real estate.
She hired a negotiator.
Real estate company has